All rise. The 55th Circuit Court is now in session with the Honorable Charles R. Evans presiding.
Good morning, you may be seated. Calling the case of People versus Tyler Joseph Miller, file 20-6532-FC. Would counsel identify for the record, please?
Good morning, Howard. Taylor Norton on behalf of the people.
If it pleases the court, Scott Moore for the defense.
And Mr. Miller, would you please raise your right hand to be sworn?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Could you tell us your name, sir?
Tyler Joseph Miller.
You may be seated if you'd like, Mr. Miller. Sir, do you understand that according to the amended information, you are charged in count 1 with the felony crime commonly known as fleeing and eluding a police officer in the 3rd degree?
Yes, sir.
And in count 2 with the felony crime commonly known as assaulting or resisting or obstructing a police officer. Do you
Yes, sir.
understand those things? Thank you, sir. And in addition, you also understand that you are charged with being a habitual offender, second offense notice.
Yes, sir.
Now, count 1, fleeing and eluding a police officer in the 3rd degree is a felony, and normally it would carry a maximum penalty of 5 years in prison and or a fine of up to $1,000, plus your driver's license would be suspended for 1 year. However, if you are convicted both of count 1 and being a habitual offender, second offense notice, the net effect of those things is that the court, in its discretion, may increase the maximum penalty for count 1 to 7.5 years in prison. It would be discretionary with the court whether or not to increase the maximum penalty for count 1 to 7.5 years in prison. And regardless of whether the court did so, the minimum end of the sentence still would be discretionary with the court. You understand those things, Mr. Miller?
Yes, sir.
Now, with regard to count 2, you are charged with assaulting or resisting or obstructing a police officer. That crime also is a felony, but ordinarily it would carry a maximum penalty of 2 years in prison and or a fine of up to $2,000. However, if you are convicted both of count 2 and being a habitual offender, second offense notice, the net effect of those things is that the court, in its discretion, may raise the maximum penalty 2 years in prison to 3 years in prison. Do you understand those things, sir?
Yes, sir.
Once again, it would be discretionary with the court whether or not to raise the maximum end of these sentences, and regardless of whether the court does so, the minimum end of each sentence would be discretionary with the court. Do you understand those things, Mr. Miller?
Yes, sir.
Now, with regard to count 1 and count 2, and to being a habitual offender, second offense notice, with regard to all 3 of those matters, you may make any of the following 3 pleas. First, you may plead guilty if you are guilty, but don't plead guilty unless you are guilty. Second, you may plead not guilty. And third, you may stand mute and say nothing, in which event the court would enter a plea of not guilty for you. Do you understand the three possible pleas you may make to count one and count two?
Yes, sir.
And that you will under second offense notice, sir?
Yes, sir.
Then answering to count one, fleeing and eluding a police officer in the third degree, what is your plea?
I'm guilty, sir.
And answering to count two, assaulting or resisting or obstructing a police officer.
I'm also guilty, sir.
Is that your plea to count two, sir?
Yes, sir.
And answering to being a habitual offender, second offense notice, what is your plea?
I'm guilty, sir.
Now, sir, do you understand that no one can make any promises for me about what your sentences will be?
I understand.
The court also informs you that if your pleas of guilty are accepted, then that means you won't have a trial of any kind, and you therefore would be giving up each and every one of the following rights: the right to have a trial by a jury, the right to have a trial by a judge sitting without a jury if you prefer, the right to be presumed innocent until proven guilty, the right to require that the prosecutor prove you guilty beyond a reasonable doubt, the right to have all of the witnesses against you to trial, and for you and your lawyer to have the chance to question and cross-examine each of those witnesses, the right to have this court order any witnesses that you might want for your defense to be required to appear at the trial, the right to remain silent and to not have your silence used against you. But finally, you also do have the right to testify at the trial. And if you choose to do so, then your testimony would be considered in the same manner as the testimony of any other witness. Now, do you understand those rights, Mr. Miller?
Yes, sir.
And do you understand, sir, that by pleading guilty, that means you'll be giving up each and every one of those rights?
Yes, sir.
Now, sir, I'm going to ask the assistant prosecuting attorney and your lawyer, Mr. Moore, to tell us what the plea agreement is, and I want you to listen to both of them very carefully. Madam Prosecutor, what is the plea agreement?
Yes, Your Honor. The offer is that defendant will plead as charged. In exchange for his plea, we will dismiss the habitual fourth and he'll plead habitual second. And we came to a sense agreement of a BK of 14 months, Your Honor.
Thank you, ma'am. And Mr. Moore, is that your full and complete understanding of the plea agreement?
It is, Your Honor. My client accepts the offer. He is pleading guilty as regards the sentence cap. Pursuant to the cases of People versus Briggs and Killebrew, and it would apply only to the initial term of incarceration and to no other term of sentence or probation.
Thank you, sir.
Thank you.
And Mr. Miller, did you hear what the assistant prosecuting attorney and your lawyer said the plea agreement is, sir?
Yes, sir.
Did you understand the plea agreement?
Yes, sir.
And do you agree with that plea agreement?
Yes, sir.
Now, has anyone promised you anything beyond what is in that plea agreement to get you to plead guilty?
No, sir.
So for example, sir, has anyone promised you that if you plead guilty, this court then would be lenient or light on you in any way?
No, sir.
Has anyone threatened you or threatened your family to get you to plead guilty?
No, sir.
Is it your own personal choice to plead guilty, And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, sir.
Do you understand everything that the court has told you?
I understand.
In light of everything that the court has told you, do you still wish to plead guilty to count 1 and count 2 and
Yes,
being
sir.
a habitual offender, second offense notice, sir?
Yes, sir.
Very well then, Mr. Miller, drawing your attention back about 6 months ago to December 15th, about 7 months ago, to December 15 of 2020, were you in Surrey Township in Clare County, Michigan on that day?
Yes, sir.
On that day and at that location, were you driving a motor vehicle?
Yes, sir.
What kind of a motor vehicle were you driving, sir?
GMC truck.
Thank you, sir. A pickup truck?
Yes, sir.
And were you driving that motor vehicle out on a road in Surrey Township?
Yes, sir.
While you were driving the motor vehicle, did Deputy Kelly Bailey of the police and the Clare County Sheriff Department, I believe.
Thank you.
Thank you, Mr. Moore. Did Deputy Kelly Bailey give you, make an attempt to have you pull over, sir?
Yes, sir.
And was that because, and when she did that, was Deputy Bailey acting in the lawful performance of her duties?
Yes, sir.
She had observed you committing some sort of traffic violation or had some other reason to stop you, is that correct?
Yes, sir.
And was Deputy Bailey in her uniform at that time?
Yes, sir.
Was she driving a police department or a sheriff department vehicle?
Yes, sir.
And could you tell that that vehicle was an official police vehicle?
Yes, sir.
Did Deputy Bailey signal to you to pull over and stop your pickup truck?
Yes, sir.
And did she ultimately turn on her siren
Yes, sir.
and emergency or flasher lights on her or police overhead lights on her vehicle?
Yes, sir.
And when she did that, did you know that you were obligated to pull over?
Yes, sir.
Did you immediately do so?
No, sir.
What did you do instead, Mr. Miller?
I tried to get away and I drove through a field and I got stuck in the mud. And when I jumped out of the truck, there was other officers that came pulling up and I turned away from them when they told me to stop.
Mr.
And-
Miller?
Yes.
Mr. Miller, you've answered the question as regards this charge. We'll get to the other part of it in a moment, if that's all right with you.
Okay.
Thank you. Thank you, Mr. Miller. And when you drove out into the field, you left the roadway and drove into a field. Is that correct, sir?
Yes, sir.
And then you got stuck in the mud in that field?
Yes, sir.
You didn't intend to get stuck in the mud in that field, did you, sir?
No, sir.
You were hoping to drive away from the deputy and escape, is that correct?
Yes, sir.
And so getting stuck was an inadvertence or an accident, correct?
Yes, sir.
And sir, drawing your attention back to May 4 of 2011, about 10 years ago, were you convicted previously of the crime of attempted fleeing and eluding a police officer in the 4th degree in the 80th District Court? In
I think so.
In Clara, Gladwin County. Were you previously convicted of that crime? About 10 years ago, sir?
I think so, sir.
And was that in Gladwin or Clara County Court, sir?
Yes, I think it was here in Clare.
Thank you, sir. Now, you were saying that after your vehicle got stuck in the mud in the field, that some sheriff deputies converged onto your vehicle and you had some sort of altercation with them. Is that correct, sir?
Yes, sir.
May I inquire with my client?
Sure. Thank you, Mr. Moore.
Mr. Miller, when we discussed the police report last night and your recollection was refreshed, it was my understanding that when you exited the vehicle, you were ordered to stop by all three of the officers stated, Kelly Bailey, Michael Hugel, and Stephen Sentz. Is that correct?
Yes, sir.
And you did not immediately stop. Is that correct?
Yes, sir.
And these individuals would testify, and you would agree that it appeared that you were running in the opposite direction as they were telling you to stop in the name of the law, correct?
Yes, sir.
They were in full uniform as this was occurring.
Yes, sir.
You would agree that this was a lawful command by any and all of these deputy sheriffs, correct?
Yes, sir.
And you knew that at the time, Mr. Miller?
Yes, sir.
Mhm.
And
Thank you, sir. Sir, drawing your attention to November 1st, 2013, in the 76th District Court in Isabella County, Michigan, is it true that you were convicted of the crime of attempted resisting or assaulting or obstructing of a police officer?
I think so.
In Isabella County, Michigan, which would be Mount Pleasant, Michigan, would be where the court is.
Yes, sir.
Thank you, sir. Mr. Moore, are you satisfied that there is a sufficient factual basis to accept the defendant's pleas of guilty to count 1 and count 2 and to being a habitual offender, second offense notice?
Yes, Your Honor.
And on behalf of the people, do you agree, Madam Prosecutor?
Yes, Your Honor. Thank you.
Mr. Moore, has the court complied with the court rule in the taking of these 3 pleas?
It has, Your Honor. Yes, Your Honor, you have. If I may, there is a procedural issue that I need to address right now.
Sure.
When reviewing the amended information along with the prosecuting attorney, I noted that the penalty provision under the habitual offender second offense notice was incorrectly stated. The assistant prosecutor has caused a second amended information to be drafted. She has signed that, provided a copy to me, and the original has been tendered to the court. For all intents and purposes, that is the charging document upon which we relied and upon which we proceeded. I'm just asking the court and the record to reflect that this minor procedural defect has been cured. Thank you.
Thank you, sir. The court did inadvertently refer to an amended information. I should have referred to the second amended.
With all due respect, Your Honor, no, that's my point. You did read off the document that we produced. After he was arraigned and entered his pleas, then we realized that the penalty provision in the habitual offender notice was incorrect, and a second amendment was then generated. So separate documents. As I've indicated, we were relying on the information as stated in the second amended information. And so if there's any issue down the road, I just want this record to show that the attorneys were aware of it, brought it to the court's attention, and the defense waives any defect that may arise from that inadvertence. Thank you, Your Honor.
Thank you, Mr. Moore. Do you agree with what Mr. Moore has stated, Ms. Short?
Yes, Your Honor, thank you.
Thank you. Very well, then, in this case, the court does find that the defendant's pleas of guilty to count 1, count 2, and the habitual offender second offense notice have been understandingly, voluntarily, and knowingly made, and in compliance with the Michigan court rules. The court accepts those 3 pleas and enters them on the records of the court. Sentencing is scheduled for Monday, August 16, 2021 at 9 a.m. Mr. McConnell, will that give your department enough time to prepare a report?
That should, Your Honor. Thank you.
Your Honor, and Mr. McConnell, Mr. Miller has been sentenced in the Isabella County Trial Court. A pre-sentence investigation report was prepared in that file, so we would have no objection to proceeding by way of update.
I didn't hear the last part, Mr. Moore.
Certainly, Mr. McConnell, we would not object to proceeding by way of an updated PSI or relying in substantial part on that previously prepared report.
Okay, very good. Thank you.
Thank you, Mr. Moore. Thank you, Mr. McConnell. Now, Mr. Miller, that pretty much concludes our proceeding today, except that Agent McConnell might have some additional instructions to give to you. And
Thank you, Your Honor.
Thank you, sir. Go ahead, Mr. McConnell.
Mr. Miller, you are lodged at the Clare County Jail, so we will have at least some information brought over for you to fill out for the updated PSI. Fill that out as completely as you can, and the agent that's assigned to the investigation will come over and meet with you and get that updated PSI completed.
Yes, sir.
Thank you, Your Honor. Nothing further.
Thank you, Mr. McConnell. And thank you, Mr. Miller. The matter will be adjourned to sentencing on the date and time indicated, Monday, August 16th. The bond status will be continued.
Would ask it to be canceled.
Very well, bond will be canceled. That way there will be no question about whether you're entitled to credit for time served from this day forward, Mr. Miller. And it might well apply previously as well. But in any event, there won't be any ambiguity, at least from this day forward. Bond is canceled. The case is adjourned to the date and time indicated. Thank you, Mr. Miller. Good luck to you.
Thank you.
You're welcome, sir.
All rise. 55th Circuit Court is now in session with the Honorable Thomas R. Evans presiding.
Good morning. You may be seated. Calling the case of People versus Jonathan Craig Stewart, file 21-6570-FH. Would counsel identify for the record, please?
Good morning, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz, appearing on behalf of the people.
Your Honor, Austin R. Rowe, appearing on behalf of Ms. Tomczyk, on behalf of Mr. Jonathan Craig Stewart.
Thank you, sir. Mr. Stewart, would you please raise your right hand to be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Could you tell us your name, sir?
John Stewart.
You may be seated if you'd like, Mr. Stewart. You appear here today, Mr. Stewart, because the people have filed a motion to revoke your bond in this case. How does your client wish to proceed in that regard, Mr. Rowe?
Your Honor, Mr. Stewart would plead not guilty in this. He's asking for an adjournment of this hearing to allow him to consult with Ms. Tomczyk. I believe he was picked up on July 2nd. He has not had an opportunity to talk with her concerning this motion. Furthermore, Mr. Stewart asked the court to continue his bond until whether it's determined at the hearing whether he violated bond or not.
That would be a novel approach. What is the position of the people
Your Honor, I
regarding
think
that?
that thank you, Your Honor. I think that bond should be set in the amount to indicate to this defendant that the court speaks through its orders. And the order of this court is that he is not to have any contact with the victim in this case. The victim and the charges in this case are quite serious. Assault with a dangerous weapon, domestic violence, felony firearm, unlawful imprisonment, possession of weapons by a firearm, and interfering with electronic communications, all as a habitual offender for. So I don't know what the bond is currently set at, but I do believe that it needs to be clear in the amount.
I believe
That
the
court
most
means
recent,
no contact.
thank you, I believe the most recent bond was set by the district court judge back in January of this year. It was set at $50,000 cash or surety or 10%. I don't know, and the bond was posted and apparently via a bail bondsman back, actually the bond was posted in December of 2020, apparently by Craig's Bail Bonds of Clare, Michigan. According to the motion to revoke the bond, the defendant allegedly was driving a motor vehicle on July 2nd and was pulled over by the state police, and in the vehicle with him allegedly was the alleged victim in this case, Shannon Cowan. Now, the court does note a bond was originally set October 14 of 2020. The bond was amended the following day. The bond was amended again on December 3rd of 2020. And the bond was amended in January of 2021. But one consistent element and requirement of each of those bonds was very simple, that the defendant was not to have any contact whatsoever with the alleged victim, Shannon Cowan. And allegedly, the defendant has failed to comply with that simple requirement. The court does not deem it to be appropriate to continue the bond while we spin our wheels, waiting to have a status conference in this matter. What the court will do is schedule the case for a status conference with the defendant and the assistant prosecutor and the prosecuting attorney and the defendant's attorney, Karen Tomczyk, to occur at 10 a.m. on Monday, July 19 of 2021. In the meantime, the court will set an interim bond with all of the original conditions of the most recent bond. And the interim bond will be a cash-only bond to be posted only in the defendant's own name in the amount of $5,000. Cash only to be posted only in the defendant's own name. Thank you all for being here. The case will proceed to a status conference on the date and time indicated. Thank you, Mr. Rowe. Thank you, Ms. Schwartz. And
Thank you, Judge.
Thank you, Mr. Stewart. We'll be in recess.
All rise.